Sanbonani.
Recording in progress.
Great, thank you so much. Dumelang Sanbonani. Good afternoon, everybody. Thank you so much for taking the time out to join us this afternoon for this really exciting and what we hope will be a really informative webinar where we seek to really unpack and just do a bit of a deep dive on the recent report that the Center for Environmental Rights recently launched called the Polluter Pays for Climate Change Loss and Damages, where we specifically look at KZN, the KZN floods as a case study. So my name is Lerato Belandran, and I will be hosting and facilitating this webinar this afternoon. And I am joining you from the Center of Environmental Rights. We've got a really great lineup of guests joining us. We've got some colleagues who will be joining us from the Center for Environmental Rights, who will tell us about the report, take us through some of the legal opinions. We also have a guest and comrade who's joining us from the Quarry Road community, who will bravely share with us some of the stories and lived experiences that folks experienced during the floods themselves. And I will ask everybody to please just introduce yourself to us at the beginning and let us know which organization you're coming from. And we will have some space and room for question and answers afterwards. So just requesting everyone to take notes of their questions and also feel free to use the chat as well. So just to get us started, I would like to officially hand over the mic to our Executive Director at the Center for Environmental Rights, Wandi Sapama, to officially get us started. Thanks, Wandi.
Thank you, Lerato. Good afternoon, everyone. Thank you for taking the time to join us in this gloomy and rainy Cape Town this afternoon. This afternoon, I have such an honor and a privilege to just make opening remarks for this report that the Center launched, titled Polluter Pays for Climate Change Loss and Damage. I will be handing over to the co-authors of the report briefly, Brendan Abdinor, our Head of Pollution and Climate Change, Acting Head of Pollution and Climate Change Program, and Michelle Sitole at some point in the program. This afternoon, we wanted to come back with this report launched here in this fashion. We have already done an official launch in Durban just before, a day before the Human Rights Day on the 20th of April. But we thought we should come back to this broader audience of civil society, colleagues, partners, and comrades to share this report with you. CER embarked on this question of loss and damage in climate change following the disaster and catastrophe that we saw in Durban in 2022. As many were asking themselves questions on what happens when there's climate change disaster. People lose lives, people lose livelihoods, people lose infrastructure, their properties are damaged. What happens? Who gets to pay for that loss? Who do they ask for compensation from? And we're grappling these questions and trying to understand what legal interventions could be there. What are the legal interventions? What is advocacy telling us we could do to respond to issues and disasters like we have seen in Durban? Scientists have gone on to describe that disaster, which is almost 2 years ago now, from the 11th and the 12th of April with the rainfall that happened there, as the most catastrophic natural disaster yet recorded in KwaZulu-Natal, in collective terms of lives lost, homes and infrastructure damaged and destroyed, and the economic impacts. It is our hope that in launching these reports, we get to add our voice as an organization to the growing body of work that is done locally and globally, done within the sector and outside of the sector, to the growing knowledge base, whereas humanity, we are beginning to connect the dots and seeking solutions to this humanity's greatest challenge being climate change. Before I hand over to the team who will take us through the report in detail, it will be an error on my part not to ask all of us to take a moment, to remember the lives lost in Durban, 443 people who lost their lives during that flooding and disaster. To date, 48 people who went missing on that day and are still unaccounted for. And I'd like to call on all of us just to take a moment of silence to remember them. And I'll hand over back to Lerato. Can we take a moment of silence? Thank you, colleagues. Thank you, Lerato. So as you listen to the report, we hope that you engage with it, you ask questions, as many as you can, and really get to use it as well as an advocacy tool as you begin to think even on legal strategies on what is the correct response to loss and damage as a result of climate change, and how do we hold our polluters accountable to pay for that loss. Thanks, Lerato.
Thank you, Andy. Thank you so much. And certainly important for us to always remember when we're doing this work, there are many lives that we lose in this struggle as climate change activists. So thank you for always bringing us back to that moment. And we certainly honor those lives that we have lost. With that said, I have the pleasure of welcoming Ustis Nomandla, who is joining us from the Quarry Road community and comrades, who's going to share with us some of her experiences that her and her community went through during those days of the floods. Sis Nomandla, if you could please come online and just introduce yourself to us and share your stories. Thank you.
Thank you. I'm Nomandla Nganula. I'm from Quarry Road West. We've been hit by the floods from 2019. There's 4 sides of the settlement. We are divided by the river. In 2019, I was staying on Mampondweni side, which is on the other side of the river. And then when we first bought the house on 2014 in Quarry Road, the stream was small. I never thought that one day I will lose my house, including the land. I never thought I would lose my house, including the land, to suffer from the natural disaster. So on 2019, I lost my house, including the land. And then we went on the other side of the settlement to rebuild where the space, there was a space. And that space was not for us to rebuild our houses. But then because of the problem of owning the land is not on our side. And then the day of the floods, it was a hectic day, a traumatic day. I can never, I don't know whether I will ever heal from it, or maybe as the time goes on. I remember we had an early warning system that we had on the group, on the WhatsApp group. Some of the stakeholders sent some messages to us telling that there's going to be a rain that will be more than what we ever seen before. The rain will be more than 2020, 2019 that we saw. And then it was kind of confusing and panicking for us. And we had to call people from the edges of the river and say to them, please be aware today there's more rain to come. And also telling people that they mustn't watch the river from the edge of the river, because once the rain starts and then the river get full, we go and stand by the edges of the river and watch the river, calling each other not to sleep today, not to just be in the house for all the time. So losing my house took away my dignity. I don't have a strong suggestions in the meetings to raise what I want to raise, because I don't have the house now. Because when you don't owning a house, they don't expect you to raise your voices as a person who own the house. And then it also took away my happiness. It also took away I would say everything that I had that time. And also it took away my right to have a house, a shelter. And then speaking about this, it's always knocking on my feelings. I'm so sorry. And then we had to rebuild again. And then we rebuilt and stayed after 2019 floods. And I never thought again I will be a victim on 2022. And on receiving that those messages from the early warning, I was just helping people. I never thought that when I get tired of helping others to take their belongings next to the road, that are safe places, only when I reach in my house, then I wouldn't even save even one thing. So it's been a trauma for us. Though Kathy tried to take us to counseling, as a community, we still have the trauma. Every time the weather changes, everyone panics and say, oh, today we don't know what's going to happen. And they keep calling. If they see that the rain is so much, those who are next to the river, they take their belongings to those who are far from the river. But still, it's not helping, because the rain that comes from the road, it's also getting into their houses, those who are also far from the river. So being a resident of Quarry Road and being hit twice by the floods, it's traumatic. It's traumatic. Thank you.
Thank you, Siyabonga kakhulu, Sis Noma. And thank you so much for sharing your experiences, your lived experiences with us. For all of us that are in this work, we know it's never easy to hear these stories, and this is exactly why we remain committed to the struggle and remain committed to the work we do, because we know the impacts of climate change affect people in a real way. So thank you so much for sharing with us, Sis Noma, and we acknowledge you and the struggles that you and the community are going through, as well as the trauma that you have experienced. And thank you once again to the work that you continue to do with Professor Catherine Sutherland, who's in this call with us. So, Siyabonga, thank you. With that, I will actually like to hand over now to Brandon Abdinor from the Center for Environmental Rights to basically tell us and take us through the report and highlighting the importance and the relevance of it at this time. Thank you, Brandon. Over to you.
Thanks, Lerato. Hi, everyone. Thanks for joining us. And yeah, I just want to echo what Lerato said. A huge thanks, Sis Nomandla. I think we can sometimes sit in our offices and look at reports and see numbers and statistics, but to really hear these sort of first-hand accounts, I think is really important. It's really important for people to understand so that we don't get numb to the reality of what's happening on the ground. I'm going to take us through basically the first half of the report, and then hand over to my colleague Michelle, who will take us through the second half, taking a closer look at the law. So with that, let me share my screen. Okay, so just to contextualize what this report is and what the work is all about. This is really the start of an additional direction for the CER and partners, supporting and complementing our existing climate change work. We've been focusing extensively on climate change mitigation, so that's often challenging government to take the right decisions to help us reduce greenhouse gas emissions. And we've also been working extensively on the climate finance side. These are two legs of the work that's been identified under the Paris Agreement, for example. And this will then be an additional leg looking at loss and damage, which is also well complemented by adaptation and climate resilience work, which is another emerging work stream around the climate change work that we do. Loss and damage is something that's gaining traction globally. And maybe just to distinguish between sort of two ways in which that term is used. Under the Paris Agreement and at the United Nations Framework Convention on Climate Change, loss and damage is handled as a sort of global climate diplomacy piece of work. And the idea there is to really set up mechanisms and funds whereby generally the wealthier, more developed countries who also happen to be historically responsible for more greenhouse gas emissions provide resources so that more vulnerable countries and regions can be compensated or get some kind of support when catastrophic climate impacts happen. It's not necessarily, or it's not what this report is speaking about. We are here looking more at how we can use the law to actually claim against those that have caused the harm. It's important to note that this is also just a slice of the work. It's not claiming to be a comprehensive report that deals with every possible aspect of the work, but really highlights certain key pieces and, as Wandi said earlier on, join some of the dots in this work as it moves forward. So the intention of the report is to firstly highlight the polluter pays principle. We'll go into a little bit more into what that means for climate loss and damage. Just to also emphasize that at this point in time, this is an advocacy report which has really enabled us to do a lot of very important basic research to take the work further. It's not about to become a court case, this particular exercise, but it is preparation for something that may result in legal action or other legal advocacy. Then the second intention of the report is to explore the legal avenues. How can we use South African law in this case to hold polluters to account? And I strongly urge that anyone that's interested also reads the two very important and excellent pieces of work that support this report. The first one being a report by Prof. Kathy Sutherland and team from UKZN, which really dives deeply into the pre-existing conditions as well as the impacts post the event in eThekwini and surrounds, as well as an excellent legal opinion done by three of the advocates from Thulamela Chambers, which explores the law in a lot more detail. We grounded the report in the context of the floods in eThekwini and around there in 2022. Why did we do that? It's firstly because that was a relatively recent event, so it's fresh in people's minds, and it's one that from a climate change advocacy point of view really captured the public imagination. In a sense, it put the climate crisis on the map for many more than for whom it was on the map before. And even the president came out in the days after the catastrophe, making very strong statements around climate change. So in a sense, from an awareness point of view, this tragic event did have some positive outcomes. Climate change impact on the floods has been scientifically confirmed, and we'll unpack that a bit. And then Durban or eThekwini is a good example of a city that has pre-existing vulnerabilities, and that can include local government failures to some extent, but it's also a city that has been grappling with and making some good progress around climate resilience. In fact, some of the interventions are hailed from around the world as being extremely progressive. And we know that many of these progressive steps are not rolled out to the extent that they need to be. So there are some that are benefiting from those interventions and others that are not yet at this point in time. And we're hoping that one of the consequences of this report is that that kind of work can be expanded and more justly distributed, if you like. And then why did we focus on the carbon majors, which we'll also explain shortly? Really, that's from a global climate justice perspective. So the carbon majors are the biggest emitters in the world of greenhouse gases, and most of those are entities that reside in the global north. So the global north or developed world, in addition to the benefits it created for itself through colonialism, also managed to build its economy or their economies by emitting huge amounts of greenhouse gases historically. And thereby they have created wealth for themselves and leave the global south of the developing countries to really fend for themselves at this point in time. So global climate justice is really how do we distribute sort of the costs of these impacts a bit more fairly, and how do we get resources from where they are currently residing to where they need to be. The impact of the carbon majors on the climate crisis has been quantified, so we now know where we sit in terms of what they've done, and ultimately they've profited and they sit with the money, which is sorely needed to deal with losses and damages all around the world. Just to say that the report does not imply letting local emitters off the hook. We know that we have some large greenhouse gas emitters in the country, and South Africa, while a relatively small emitter compared to some of the largest developing countries, is still a very carbon intensive country and has a lot of work to do. So the legal opinion and the exploration of how we can use the law would apply to local emitters as well. And in fact, the pathway to taking action against them is easier in many respects. But for this purpose and for that global climate justice lens, we focused on the carbon majors. It also doesn't imply letting local governments off the hook. They're also very responsible for how climate response is handled, and they need to be engaged with to ensure that they are fulfilling their duties around climate resilience and around making sure that climate justice is implemented. So taking a look at eThekwini in a bit more detail, like many cities, or possibly even most cities, it sits with a number of pre-existing vulnerabilities. It's the city as we know it today is born out of colonization and apartheid, And obviously these things are woven into the architecture and the structure and the service provision of the city. So that is a challenge, and one that is certainly common to all South African cities. And many communities and people are to a large extent left to fend for themselves, and find themselves subject to vulnerabilities that more privileged groupings do not have to face, or those privileged groupings may have resources to manage the risk and disruption in the way that others can't. All of this is exacerbated by governance and management failures, by the trend of urbanization. We've got the background context of poverty, inequality, and unemployment, and we also have capacity challenges. And then, of course, we have the ever-intensifying climate crisis. On the other hand, eThekwini is a city that has been engaging with climate resilience and risk management to some extent, again, not equally, and has been very actively engaged in water and sanitation innovation, informal settlement upgrading, community ecosystem-based adaptation, for which it is quite well known. And that can include things like water and soil management, flood attenuation, and catchment management. So, for example, making sure that your waterways are clear of alien vegetation and other blockages and can carry water away as quickly and efficiently as possible. In 2017, the World Bank estimated that these ecosystem services basically provide 4.2 billion rands worth of services per annum. And the interventions have been valued at up to 62 billion rand. So just to give you an idea there to how that's sort of calculated, they calculate, for example, what work the ecosystem does to protect us, to provide us with services, and then looks at what an equivalent human intervention would cost and makes those comparisons to be able to come up with numbers like this. Durban has also been involved since 2013 with a riverine management program. And it's been calculated for every rand that is spent on that program, between 1.80 rand and 3.40 rand of municipal and social benefits are realized, in addition to potentially creating up to 9,000 jobs. So while these interventions are not extensive enough, and it would be great to see them replicated and rolled out elsewhere, Durban would be far worse, in a far worse position without them. Another intervention that the city has is the community-based flood early warning system, which was established in 2015. And it's a collaboration between city officials, researchers from UKZN, civil society, and community members. And this is in both formal and informal communities. And that is centered around the Palmit River. It has been estimated that this early warning system, which uses WhatsApp, so one gets the warnings from the sort of central weather monitoring services, gets filtered through the city and these messages end up in the hands of actual community members, and it's estimated that the system could have saved between 250 and 400 lives in the 2022 floods. So all of this kind of innovation and interventions could be strengthened and replicated if the money is there and if the political will is there. Going into the events which actually caused the disaster we're talking about. So the first of these is the extreme rainfall. What happened is that a system known as a cutoff low was present and developed. And that resulted in up to 300 millimeters of rain falling in 24 hours. So that's a third of a year's rainfall happening in one day. KZN is no stranger to cut-off lows. So we can't say that cut-off lows are purely as a result of human-caused climate change, but as we'll see just now, the climate change does intensify events like this. The second event is flooding. So extreme rainfall and flooding are very interrelated, but they're not the same thing exactly, and they need to be looked at separately. Not all extreme rainfall, for example, would give rise to flooding. So certain other factors need to be looked at, such as groundwater saturation, the conditions of waterways, and of course the urban environment itself. The way in which it is built and planned and maintained obviously has a very strong bearing on what happens with that immense amount of water that falls in a very short time. And again, the conditions of poverty, inequality, and informality, as well as poor service provision, poor waste management, and poor spatial planning are factors that can aggravate a rainfall event so that it becomes a flood. When it comes to the contribution of climate change or global warming on this particular event, or in general terms, firstly, the Intergovernmental Panel on Climate Change, most recent assessment report 6, has found that in general, the intensity and frequency of heavy rainfall over most land regions increases with increased global warming, and also confirms what most of us know as well, is that obviously increased greenhouse gas emissions is the main driver of these changes. It also finds that this will increase with additional global warming. So going into how do we know whether climate change played a role in the rainfall and the floods? There is a group of scientists from a number of countries around the world that have formed the World Weather Attribution Collaboration. And these climate scientists perform rapid studies of events to determine whether global warming or climate change was a factor. They've been doing this work since 2015, although this type of science has been visible from as early as 2004. And the World Weather Attribution Service has now done 50 event studies. And it's really interesting to go take a look at the website, how they dissect various floods and other events, droughts included, and make findings on the global warming contribution. There's also a climate change focused website and service called Carbon Brief, and that maintains a live database of climate change intensified or caused events. Currently, there are more than 500 events on there, and it's been found that 71% of those have been intensified by global warming. How World Weather Attribution does its work is it uses very sophisticated computer modeling based on observed weather data, and it simulates weather and climate patterns. So it simulates the modern climate, which is at this point, 1.2 degrees warmer than pre-industrial levels, or when we first started burning fossil fuels. And then it models a climate without that increased warming, so without the sort of increased greenhouse gas load in the atmosphere, and it compares them. And in using this method, it's able to then calculate to what extent global warming has intensified an event. The findings in terms of the 2022 floods were that the event now has a return time of 20 years versus a return time of 40 years in a cooler world. So in other words, it's likely to happen twice as often. The probability of the event doubled as well as a result of global warming, and the intensity of the event was increased by between 4 and 8% as a result of global warming. Just as a matter of interest, the Cape Town Day Zero floods from, I think, 2017 were found to be 3 times more intense and likely as a result of global warming. So in a sense, if one is going to go to court for something like this, obviously the stronger that signal is, the stronger the case could be. In terms of impacts of the flood, and Wandi touched on some of this earlier, 443 lives lost with 48 people missing, 26,000 dwellings were damaged, 600 schools were damaged. Infrastructure damage was estimated at around 10 billion and total economic loss at 17 billion. We don't have insight into exactly how those numbers are made up, but there's a good chance, and we certainly need to question whether many of the losses of poorer and more at-risk communities and the informal economy are properly calculated in those numbers. In addition to that, we've got impacts such as trauma, lost schooling, and the breakdown of existing social structures, which are obviously, some of those are very hard to quantify in money terms, but in terms of devastation, they're very, very real. So looking at remedies and reparations, Michelle just now is going to talk from a more strict look from the existing law at the moment of what kind of damages are claimable. This is a bit more of a zoomed out look. And it's worth remembering that if money starts changing hands as some form of compensation for loss and damage, it may not necessarily be as a result of an award, which is the outcome of a court case. Certainly that is one of the angles. But there are other ways, and that's why it's worth looking at this notion of reparations and remedies quite broadly. For example, one could have a more progressive approach to using carbon taxes, so ring fencing carbon taxes collected and applying them to climate loss and damage. And an interesting development last week in the United States, the state of Vermont, the legislature there has introduced a bill creating a climate super fund. And the idea is that this super fund will pay for losses and damages, for example, and it's funded by imposing levies on fossil fuel companies and large emitters. So that's also a direction that this could go in. From a more traditional look of compensation, so this is backwards looking. Obviously, one could think about compensation for infrastructure damage to homes, goods, possessions, community infrastructure, both formal and informal, compensation for disruption of services such as water and sanitation, transport, disruption to food production, including small-scale farming, physical and mental health impacts, business losses, again, both formal and informal. And then the sort of more non-economic, but there's an increasing exploration and application of this in our law. So the loss of a sense of place, the loss of social cohesion, the loss of heritage, and the sacredness of a place to people. And all of this, when one considers reparations, need to be informed by a climate justice perspective. So really taking into account who's got access to what. More wealthier parties have access to insurance, for example, whereas many in informal settings will not. And then we can also look at forward-looking contributions to or reparations, such as climate-resilient upgrading of informal settlements, climate-resilient upgrading of formal infrastructure and social assets, enhancing and replicating initiatives like the community-based ecosystem services and the community-based early warning systems, creating green jobs and a green economy, mechanisms for healing trauma, and also funding participatory structures such as climate assemblies, where all affected role players can get together and have the conversations about what is needed and what the risks are. So who would pay for all of this? So the polluter pays principle is something that is now well recognized in law and in environmental justice circles. It's something that first came to prominence in 1972 when the Organization for Economic Cooperation and Development adopted it. In 1992, it was incorporated into the Rio Declaration. And our own National Environment Management Act of 1999 has polluter pays as one of its fundamental principles. So going on to the polluters in a bit more detail. Since the 90s already, when climate change hit the mainstream in a certain way, certainly within the scientific community and government decision makers for that matter, there's been increased pressure to understand the greenhouse gas emissions landscape. The IPCC, in its first assessment report, already put the issue on the map. And we are in a situation now where we know what the sources of major emissions are and where they are. Knowing what those emissions are does rely on reporting. So basically, an emitter will maybe be conducting a particular activity, like say a gas-fired power plant, and they'll know if your plant is of this technology and is generating this amount of megawatts, we'll know what the greenhouse gas emissions are. So there's a bit of a lag time, and there's obviously a risk that that reporting is not accurate, but at this point in time, it's probably the best that's available. Then a scientist by the name of Richard Heady, who also established the Climate Accountability Institute, came up with the concept of the carbon majors. So these are 90 entities that are responsible for 63% of carbon dioxide and methane emissions from the period 1854 until 2010. So that really put these large emitters on the map, and giving them a name like that, I think was quite beneficial for advocacy work. And then looking into the fossil fuel industry a bit more closely as well, we know that burning fossil fuels is the major cause of global warming. And there were already an initial wave of lawsuits in the mid-2000s, which were not that successful. One of the things that the fossil fuel industry did is convince courts and sort of the public generally that the responsibility doesn't lie with them, but with those that use their products. And those were defenses that at that time were quite difficult to get around. So the wave sort of died down a bit. And then the launch of the Carbon Major Report, as well as the growth of attribution science, which I will explain shortly, really reignited these efforts, and there are now around 60 cases against large emitters, again, mainly fossil fuel companies. The types of claims that are being brought, so there are retrospective Polluter Pays claims, which is very much the subject of this report, as well as prospective claims, so looking forward as to what damages are still to come, or a combination of both. Then there's a whole stream of climate misinformation cases, and then there are also more increasingly directors' liability cases. The misinformation cases are really interesting because they really reveal the extent to which the industry knew what the potential harms were, and how it went to great lengths to hide that. So really the cases reveal evidence, including internal memos from a company's scientific team to the top management, for example. And there are now numerous of these at various stages in various courts around the world, particularly in the USA. Some of the companies have been proven to know about the harms as far back as 1959. And in the 70s and 80s, there were concerted efforts to mount misinformation campaigns, to cast doubt on the science, to basically convince the public that they're not doing anything wrong and they should be allowed to continue doing what they're doing. There's also an interesting recent report called Time to Pay the Piper, also by Richard Heady and a Professor Grasso, and that looks at holding the top 20 emitters accountable. They calculate that climate loss and damage between 2025 and 2050 will be up to $99 trillion. And on their calculations, Saudi Aramco, which is just being used because it's the top of that list, would be paying $42 billion per annum in terms of offsetting loss and damage. And then finally, just to cover the attribution science. So this is the other development that has allowed claims like this to basically come into being. And to really institute a claim successfully, you have to prove causation, which Michelle will go into a lot more. So these different legs of attribution science put those links of the chain together. so that you can actually say there is this link between those emissions over there and that damage on the other side of the world. The different legs include climate change attribution. So that's really looking and understanding the human causes of climate change. And then we have source attribution. So that's the extent to which the emissions from a particular entity, like a fossil fuel company, for example, contributes to climate change. And that's really where you get your pro rata share from, if you like, when you want to consider who's liable to pay for what damage. Then there is extreme event attribution. So that's the extent to which climate change contributes to a particular event. And then impact attribution, which looks at the impact of damages on the ground and assesses the intensity of those impacts on the ground, and to what extent those were caused by climate change. I'm now going to hand over to Michelle, who will take us through the legal side of it in terms of the South African law. Thanks.
Thanks, Brandon. Afternoon, everyone. As Brandon mentioned, I will be touching on the legal aspects. Essentially, what I'll be touching on is the legal opinion that Brandon mentioned earlier. This opinion was prepared by 3 advocates, and what I'll be doing is just essentially a high-level summary of that legal opinion, using the KZN floods as a case study. So my presentation will basically just look at 2 sort of elements to this. There's sort of 2 elements to this presentation. Essentially, the first leg being the necessary legal procedures before bringing a claim, what you'd need to satisfy before bringing a claim to a court. And then I'll go into sort of the elements that you would need to prove once you've gone through this first hurdle. So going through your legal procedures, you'd need to firstly have you firstly need to make sure that a court has jurisdiction. There's a hurdle of foreign act of state doctrine and principles of state immunity. Then you have choice of law and the cause of action, which we'll touch on later on. And then there's the issue of standing. And then finally, I'll touch on parent company liability. So jurisdiction essentially is the authority of a court to hear, decide a legal dispute between parties and make an order that it can effectively enforce. An individual or group that intends to bring a claim against a carbon major will only be entitled to do so in a South African court if jurisdiction can be established for the South African court. So where a carbon major is located in South Africa, the relevant division of the High Court in the area where the carbon major is based would have full jurisdiction to hear and decide any claims for damages and any related remedies against the carbon major. Although most carbon majors may have locally registered South African subsidiaries, most of them are unlikely to be located in South Africa, as Brandon mentioned earlier. A lot of the carbon majors are based outside of South Africa. Where a foreign carbon major has a South African registered subsidiary, it is important to bear in mind that the parent and subsidiary companies are distinct entities with separate corporate personality and separate limited liability. A South African subsidiary would therefore not automatically give a court jurisdiction over a parent company and vice versa. And then secondly, when it comes to a foreign act, the second hurdle that you'd have to get through before bringing a claim of this nature is the foreign act of state doctrine and principles of state immunity. So this is one of the hurdles that you'd have to get through, because it may be difficult to bring a claim against a carbon major owned by a foreign state because of this principle under international law about state sovereignty and state immunity. as courts may decline to determine a matter which relates to the alleged unlawful conduct of a foreign state. And then when it comes to the choice of law and bringing a claim against a foreign carbon major, which did most of its polluting beyond South Africa's borders, a South African court will have to determine whether the substantive issues of law must be decided in terms of South African law or the relevant foreign law. When dealing with a foreign defendant, our courts have stated that the appropriate starting point is to apply the law of the place where the wrongful act was committed. So for instance, as an example, if the wrongful act was committed in the United States, then the starting point would be applying the law of the United States. Therefore, the general rule is that the law applicable where the wrongful act took place will apply, unless there are circumstances that justify a departure from this general rule. There's not yet clarity on whether the departure would be justified, when the departure would be justified. However, relevant considerations that have been considered by the courts include which country has the most significant relationship to the wrongful act, the presence of shared jurisdictional connection between the parties, and whether there are grounds of public policy that warrant applying South African law in preference to the relevant foreign law. However, leading academics suggest that in cases of uncertainty, the place where the wrongful act was committed ought to be determined by the place of the damage, where the harms or losses giving rise to the claim was suffered. So using the KZN case study as an example, you would use South African law because the place where the damage took place would have been in KZN. So you'd use South African law in that instance for your choice of law. Cause of action under South African law, a claim for damages would be approached through what is known as the law of delict. Some in other countries, they refer to it as torts. Other avenues to claim for damages may be available, including constitutional damages. However, constitutional damages are a little bit tricky. A claim for constitutional damages would be limited where a court finds that a claim under the law of delict is unavailable or inappropriate. The application of constitutional rights and obligations is confined to within South African borders, with limited application outside of our borders. Therefore, in respect of a foreign carbon major, it is unclear whether the Constitution and by extension constitutional damages would be available to South Africans seeking to bring a claim against a foreign carbon major. When it comes to standing under a common law, any person who claims that they have suffered harm has a right to bring a claim in a South African court. A person has this right to bring a case in their own interest, so long as they have a direct and substantial interest in what is being asked for from the court. The Constitution now also allows more situations for individuals to take a case to a court on constitutional matters, including cases of public interest, representative standing, and class actions where a group of people would act as representatives for a larger group. A claim may therefore be brought on an individual basis on behalf of a larger group, and where the resolution of their claims depends on substantially the same set of facts and same set of facts and the same question of law, then you can bring it through a class action. Given the scale of climate-linked disasters and the size of potential classes of victims, the class action mechanism has the most advantages. It includes making justice accessible to a larger group of individuals with limited means, whose claims may not be big enough to justify approaching the court on an individual basis. And then when it comes to parent company liability, generally a parent company and its subsidiaries are distinct entities with separate corporate personality and liabilities. Our courts recognize certain relationships that can lead to vicarious liability, such as employment or similar relationships where there is a similar level of control. Where vicarious liability is proven, one party is held responsible for the actions of another. even if they were not directly at fault. It involves holding one party strictly liable for the negligent actions of another. The relationship between the parent and the subsidiary could be similar to that of a principal and an independent contractor. The principal is not automatically responsible for the contractor's actions, except where it is shown that the principal played some sort of was negligent in the role that they played in the wrongful conduct that took place, and they may be held accountable in that instance. Negligence in this circumstance could be in selecting the contractor or not implementing proper safety measures and supervision and control. So what I've just discussed earlier was just the procedural things that you'd need to get through before you'd have to bring your actual claim. So the legal opinion essentially said that what appears to be the most viable route for a claim for climate loss and damage would be the law of delict. In order to bring such a claim, one would need to prove the following general elements of a delict, which is harm, wrongful conduct, fault, and causation. Wrongfulness is one of the elements, and I'll deal with each of the elements in detail as I go through the presentation. So I'll deal with wrongfulness first. A carbon major's liability for loss and damage is dependent on the wrongfulness of its relevant acts or omissions, and omissions are essentially a failure to act where it had a legal duty to do so. Wrongfulness involves a legal determination of whether it would be reasonable to impose liability on a defendant for the damages flowing from specific conduct, assuming that all of the other elements for delictual liability have been proven. Reasonableness in this context is assessed based on considerations of public and legal policy informed by constitutional values. The approach to determining wrongfulness will depend on the nature of a carbon major's alleged conduct, whether this is a positive act or an omission or statements, false statements that Brandon touched on earlier, and the consequences, the damage to property, person, pure economic loss, nervous shock, grief, etc. When it comes to, wrongfulness, you'd have to determine the nature of the conduct and the consequences. So wrongfulness will be presumed where a carbon major's actions result in harm to people or their property. This presumption is based on the common law right to be free from harm to oneself or one's property. Where individuals seek to bring a claim have suffered personal injuries or damage to property due to alleged actions of a carbon major, wrongfulness would be presumed. If a carbon major is accused of not taking action or making misleading statements, wrongdoing is not automatically assumed, even if harm does occur. The person making the claim would have to provide evidence supporting the inference of wrongdoing. The relevant considerations for determining wrongfulness. Wrongfulness is determined after the fact, assuming that all of the other elements, as I mentioned earlier, have all been proven. So that's your fault, causation, and harm have all been proven. The question asked by the court as part of this assessment of wrongfulness of a carbon major's conduct is whether or not it would be reasonable to impose liability. This is assessed based on the considerations of public and legal policies informed by our constitutional values. These considerations include the constitutional rights and principles, including the Section 24 constitutional environmental right, which we know now in deadly air as a right that is immediately realizable, the nature and extent of the harm, the social utility of the conduct, and this is basically the usefulness of the conduct for the public. And then you have your actual knowledge that the act or omission might result in harm, reasonable foreseeability of harm, a pre-existing duty, and the presence of any statutory regulation of greenhouse gas emissions that impose a legal duty on a carbon major to act positively to prevent harm. And then the second element that you'd need to prove in bringing a claim against a carbon major for climate loss and damage is fault. A carbon major will only be liable if it is shown that it was at fault. Fault is established by proving either negligence or intention. In most cases of climate-linked disasters, intention would be difficult to prove. So you'd have to rely on the lower bar of negligence. Negligence involves an assessment of whether a reasonable person in the position of the defendant, so in this case, your carbon major, a reasonable person in the position of a carbon major, would foresee the reasonable possibility of their conduct injuring another person or their property or causing patrimonial loss. So that's financial loss. And secondly, would they take reasonable steps to guard against such an occurrence? And the defendant failed to take those steps. So you'd need to prove all of those things. And a person seeking to bring a claim against a carbon major would have to show that the harms of climate change were foreseen by a carbon major and were reasonably foreseeable. A reasonable person in the position of that carbon major would have taken steps to prevent the harm from occurring, and the carbon major failed to take those steps. So when it comes to reasonable foreseeability, courts limit liability to harm that was foreseen or was reasonably foreseeable at the time of the wrongful conduct. If the harm is too unlikely to foresee, it cannot be the basis for legal action. What is reasonably foreseeable depends on a number of factors and the particular circumstances of each case. These may include the likelihood of the harm occurring if the harm does indeed occur, what is the extent of the damage likely to be, and the efforts required to prevent the risk from occurring. If the likelihood of the harm occurring is very high, then the harm is usually considered to have been foreseeable, even if the extent of the potential damage is very small. On the other hand, where there is less likelihood of the harm occurring, but the degree of the harm would be significant, the harm may also be considered to be reasonably foreseeable. On current scientific knowledge, it is certainly reasonably foreseeable that industrial production and the burning of fossil fuels resulting in substantial greenhouse gas emissions contributes directly to climate change, which results in natural disasters. There's likely to be significant debate about when such harm was foreseeable, which could serve as a potential cut-off date for liability. So for example, if a carbon major could show that these harms were only reasonably foreseeable from the early 2000s, as an example, this could potentially immunize carbon majors from liability for all acts and emissions before the period of 2000, or before the early 2000s. It could be sufficient to prove that a carbon major foresaw or to have reasonably foreseen that their actions contributed to a general risk of extreme weather and flooding of the low coastal areas in Southern Africa induced by climate change. It may not be necessary to prove that the exact events which took place in for instance, KZN in 2022 were foreseen or were reasonably foreseeable. And then the other leg of proving fault is preventability. Once it is shown that a reasonable person would have foreseen the possibility of harm occurring, the question then turns to whether a reasonable person would have taken measures to prevent the occurrence of the harm. This involves a weighing up of various competing factors. And then the third leg of the third element that you'd have to prove in bringing a delictual claim is causation. A person bringing a claim against a carbon major would have to prove that a carbon major's negligent emission of greenhouse gases and other wrongful acts is causally linked to a particular climate change related event and resulting losses. Causation in our law turns on two separate inquiries. The first is factual causation, whether a carbon major's negligent conduct was the factual cause of the loss. And then you have legal causation. If factual causation is established, where the carbon major ought to be held liable for the losses, which turns on whether the negligent conduct was sufficiently closely linked to the loss to justify holding a carbon major liable. The first sort of test for causation, factual causation, when it comes to climate loss and damage cases, which are an extreme example of cumulative causation, in which multiple causative factors contribute to a resulting harm. Our traditional but-for test used in our law for factual causation won't necessarily suit this type of case. because the test asks, had the negligent conduct not occurred, would the plaintiff have suffered the loss? In the case of negligent omissions, a failure to act in the presence of a legal duty, this test asks whether the loss would have occurred had the defendant taken positive, reasonable action. On a strict application of this test, it would be all but impossible to show that but for the negligent actions or omissions of one or more carbon majors, the KZN floods and resulting losses would not have occurred. There are at least two alternative routes available in our law to factual causation, which have been endorsed by the Constitutional Court. The first is the flexible approach to factual causation. The flexible approach merely requires a probable reduction in risk of loss to establish factual causation. On this approach, a person bringing a claim would potentially succeed by showing that had a carbon major taken reasonable non-negligent steps to reduce its greenhouse gas emissions or refrained from other wrongful conduct, there would have been a probable reduction in the risk of the KZN floods and resulting losses occurring in with the same intensity. The second test for causation is the material contribution test, which has also been endorsed by the Constitutional Court. In terms of this approach, factual causation can be established where the negligent act or omission caused or materially contributed to the harm giving rise to the claim. On this approach, it would be sufficient to show that a carbon major's negligent conduct made a material contribution to the intensity and duration of the KZN floods and the resulting losses. There is a third option to factual causation, which is the development of our common law. So there is a possibility of developing our common law in line with Section 39(2) of our Constitution to recognize a further test for factual causation. Other jurisdictions have adopted similar approaches, such as the negligent exposure to risk test. The requirement of causation has been found to be met where it is shown that the negligent conduct exposed a person to risk, even if it cannot be determined that even if it cannot be determined what caused the losses. Taking this route would require presenting evidence and argument justifying the development of our common law. Then finally, legal causation. Legal causation is a test that seeks to limit potentially limitless liability. There's an overlap between the question of wrongfulness and the test of legal causation, as the question of remoteness of the harm occurring, which assesses reasonable foreseeability of the harm, is a relevant factor. The less likely the harm is from the conduct in question, geographically, temporally, the more difficult it will be to establish legal causation unless the harm was foreseen or reasonably foreseeable. Legal causation may be broken by a new intervening event, which is said to break the chain of causation, thereby making it unfair to hold a defendant liable for the losses suffered. A determining factor is the evidence of reasonable foreseeability. One could argue that it is foreseeable that those worst affected by climate-linked disasters are the most vulnerable, who live in areas where governments are less equipped to address these disasters. In that context, state dysfunction, incapacity, and unconstrained development and informal housing would arguably not qualify as a new intervening event. It is also well established that intervening omissions as opposed to acts are generally less likely to constitute an intervening event. This is so even where an intervening act consists of negligent failure to prevent damage caused by the defendant's wrongdoing. Therefore, state failure or state dysfunction alone would not necessarily be sufficient to break the chain of causation. In addition, the vulnerable position of the victims of floods and their desperate circumstances would not by themselves be sufficient to break the chain of causation. Our law has recognized that a negligent party takes their victim as they find them, which is what we refer to as a thin skull rule. So any pre-existing physical, psychological vulnerabilities do not amount to causation-breaking events. By extension, a victim's poverty, their lack of suitable housing, and inability to make proper preparations for flooding should be regarded as irrelevant. Ultimately, considerations of public policy, fairness, justice will play the most decisive role in considering legal causation. And then finally, when it comes to remedies, a person or persons seeking to bring a claim against the carbon major have a range of remedies to choose from, which include a declaration of liability, damages, monetary compensation, and interlocutory relief. This relief is, however, limited where a foreign carbon major is involved due to the court's inability to enforce orders made in South African courts against the foreign carbon major. However, the most important thing to remember here is a person bringing a claim is bound by the once and for all rule. This means that in bringing a claim, you must bring all of your claims in one action. Your financial losses already sustained and all future anticipated losses need to be claimed in one action. And then finally, in success in bringing a claim for loss and damage will by no means be an easy road to victory. It will require extensive research on the carbon major, that damages are sought from, its activities, its links to South Africa. In addition, an extensive evidence gathering process will be required to the extent on the extent and globally distributed nature of a carbon major's polluting activities, along with expert attribution evidence to draw the necessary links between the carbon major's emissions and climate change related harms. And this is what Brandon had touched on earlier, that attribution science is quite important, especially when you're bringing in the links with causation, in terms of proving causation. And having said that, there does exist the potential for a viable loss and damage claim under our law of delict against a foreign carbon major. I'll hand it back to you, Brandon. Thank you.
Thank you, Michelle. Yeah, that was great. I think we can see from that there are many hoops to jump through before we'll actually be in court and claiming, but also that one can, that the pathway is viable. And remembering also that this sort of pressure is now being applied in many countries around the world, which can all help to start hopefully creating this kind of sea change that we need to see. I'm going to just wrap up with the calls to action in the report and then hand back to Lerato for Q&A and any discussion. So in terms of calls to action for lawyers, I think it's important continue to engage with climate change knowledge and with the law and push the limits. Michelle mentioned there that the common law could use some development, and the law does evolve. As society evolves and its expectations, the law does too, and lawyers have a big role to come up with creative arguments and ways in which they can make the court understand the nature of this relatively new issue from a legal point of view anyway. For local government role players is really understand those interventions that are in eThekwini that are working and that are saving lives. Enhance them, replicate them, push for them, and let's see them rolled out in other places and save lives as we go. Politicians and high-level state decision makers should understand that their climate harming decisions are going to have huge implications. Whatever benefit they think they might see from some of these activities, the costs of the impacts of the climate crisis are ultimately going to dwarf those. So perhaps to get more aligned with the protection of people and planet. Carbon majors and fossil fuel interests realize that you're being watched, that scores being kept, that events are being recorded, and that claims are being constructed. And perhaps they could consider how they will, first of all, really adopt a meaningful decarbonization journey, and how they could perhaps come up with mechanisms for compensation before that is going to be forced from them. And for the climate justice movement, keep on expanding the knowledge, sharing that knowledge, sharing information, applying pressure, and exercising the very important watchdog role that is being exercised. With that, thanks. Back to Lerato, and yeah, inviting anyone to ask questions, make comments, etc.
Sure. Thank you so much, Brandon, and Michelle from the PCC team, from our community comrades that we've heard from for sharing the stories that obviously make a huge impact in contributing to this, and to Professor Kathy Sutherland for also working with our community comrades and gathering this incredible data. I'd like to open it up now to questions and answers. I see we have Clement who has a hand up. Go ahead, Com.
Good afternoon. May I audible enough? Okay, I just want to ask from the Lerato side, on the law side, because now we are dealing with the foreign polluters, and we have the doctrine. The doctrine always prohibits the domestic court of one sovereign state from questioning the legal of another sovereign state conduct. It's a doctrine, and then now we have to be careful as South Africans. The court has set out the following main guiding principle, that the doctrine is applicable regardless of whether there are proceedings against the foreign state or whether any claim against the foreign state assets. The court also extends the doctrine to any matter where a foreign state conduct or fail to examine or be determined. And secondly, whether the doctrine applies will depend largely whether the act's complaint or the private or the government nature, because now we are dealing with environment and we are dealing with climate change. It's global.
Does Clement know who's muted?
Clement, you disappeared there for a moment. Or at the end, I think.
Yes, I think.
Comrade. Hello?
Yes, comrade, I think you're back. We just lost you for a bit there. Don't know if you can just repeat the last bit of your comment and question there, Com.
Okay, my last comment is we have to make it clear to the communities, also to our global communities, that it is clear that the act is relied on where or were carried outside the foreign state own territory. The foreign act of the state doctrine would not apply. You see, the doctrine is premised on the simple principle that every sovereign state is bound to respect the independence of every sovereign state. And the courts of one country will not sit in judgment on the act of the government of another country within its own territory. We have to, on this is a new thing, the climate change is a new thing, it's a new pandemic. We have to amend these things, because now people will come in South Africa and pollute, bringing pollution, knowing that when they go back to their countries, they won't get liable or they won't get accounted for. But we have to be careful about that, because other things have been done for favor to other countries. Thanks, comrades. Thank you. That's my comment and that's my question. That's my worry as a concerned South African and Earth citizen, that we have to amend other laws, because people will come and make mess in South Africa and run away to America. And then we don't have powers and we know them. Now we have to come to that point. Thanks.
Thank you, Com. Michelle or Brandon, who can answer that?
Thanks. I'm happy to jump in. Yeah, Clement, thank you. Those are very good points, and the opinion does unpack the doctrine in a lot more detail. So the difficulty really comes in where the carbon major or the emitter concerned is a state-owned entity, because that's where we might get that limitation coming in. However, there would be no challenge on that basis to actually going after a privately owned company that is the carbon major. And yes, I think the nature of climate change is such that we do need to see development of the law, and perhaps there needs to be pushback against that doctrine. And I don't know if there might be something coming out of the ICJ opinion, for example. But yeah, Michelle, I don't know if there's anything you want to add there.
No, you captured it beautifully. Thanks, Brandon.
Okay, thanks. Thanks, comrades. Clement, I hope you're okay there. We've got a question on the chat from Richard, who's asking, given that such litigation will take years to unfold, have we thought about how this work may also be fed into assessment of risks associated with fossil fuel investments?
Thanks. Yeah, I think this is another whole angle that's developing a lot, and we're starting to see the advisors of corporations highlighting litigation risk. And we also have observed how share prices of companies like that tend to drop when legal action is instituted. So yeah, I think this possibly will take years. We never know. Let's see. But certainly that's the kind of advocacy that can flow from this exercise. And I would imagine that even the launch of a report like this might be noticed in some circles.
Comrade Irene, you have your hand up. Irene,
Yeah,
can you hear?
yes, please. Can you hear me?
We can. Go ahead.
Yeah, sure. Thank you. Thank you. My name is Tondigwe Irene. I come from Uganda, and I work with a community-based organization called Women for Green Economy Movement Uganda. Talking about the loss and damage, I think first and foremost, we need to always differentiate the non-economic loss and damage and the economic loss and damage. We all know that very many CSOs, donors, and other development partners are basically focusing on the economic loss and damage, and the non-economic loss and damage aspect is being left behind. So coming from a community that where oil is being extracted in Uganda, the East African crude oil pipeline, it has not only increased on the climate change impacts, but also has really impacted communities psychologically, not only causing the economic loss and damage, but also the non-economic loss and damage. But we've seen donors, we've seen CSOs are not focusing on how communities are being really affected emotionally. You know, the aspect of how communities, how people, especially marginalized communities, marginalized women, that all the impacts of climate change are embedded on them. You know, we've not given it a priority to address the non-economic loss and damage, and calling upon like climate change is a global issue. So if we only focus on the visible aspect, how about the non-economic, how people are feeling, how they are stressed, how are they dealing with the depression, how are they dealing with the stress, trauma? People are running mad because of these climate change impacts. So as this webinar, I would like to know how we can really help our communities to handle the non-economic loss and damage, like our friend who shared how really her house went on. It did not only affect her physically, but emotionally. How are we trying to solve that? Yeah, thank you. Over to you.
Thanks, Irene. Yeah, I mean, I think that's a really important point. I think historically we probably come from a situation, and I'm talking about even hundreds and thousands of years, where sort of more economic loss and damage was understood and obvious and that sort of thing. And I think non-economic loss is one of those evolutions of the law that we speak about. So I think it would be really it's important that those stories are known and documented. For example, in our cancel coal case, we actually had an expert do a report on the mental health impacts of climate change. In the one of the Shell cases recently, the loss of sense of place and the sacredness of the ocean in that case was quite persuasive to the courts. So I think that as consciousness expands, and those forms of losses get increasingly recognized, then we're going to see them increasingly coming into claims. Yeah, so it's just something that it's one of those areas that we all need to continue pushing all the time. And I think hearing from Sis Nomandla earlier, this really brings home how, you know, some of these things can't be counted in monetary terms. They actually have absolute impacts on our very being. And then it's also up to the lawyers to weave those descriptions of those kinds of losses into court papers and advocacy work.
Thank you, Brandon. I will actually post the link to the report you're referencing in the chat for any comrade who is looking to look into that, the consequences and the effects of climate change impacts on our mental health. And please feel free to use these resources that we have also made available. We have a question from Claire, who also asks, I'm not sure if that maybe has been covered a little bit, Brandon, on
Rato, I think you're frozen, but I see the question. Yeah, so that's really important, is that these things get documented. In fact, one of the ideas flowing from this report is to maybe set up a Southern African or whatever, in whatever formation, loss and damage nerve center, so that we can get a depth to the descriptions and the nature of the losses and damages. You know, it's easy to sort of have official stats at the top, but if that is happening at many levels, including long-term impacts, many of these kinds of events give rise to a breakdown in people's resilience, a breakdown in social infrastructure, and again, that sense of place. And so the richer the information gathering is, the richer the claims can be, and I guess the more creative the asks can be from the other side. So yeah, that's something that should be done, and ideally that should ultimately be networked and become a well-known common knowledge base. I think I'll just then ask Tabitha to ask her question. Lerato might be having problems.
Hi everyone, and thanks for really cool presentations. I don't know if this is already answered in the report, so this will show up the fact that I haven't yet read it. But I was wondering, how do you go about identifying the company that you want to target, considering that linking the kind of harm to a particular company, it's usually a collective kind of harm or damage that's done by a whole range of companies. So, I mean, you're talking about the top polluters, but would it then be a case against the top polluters or just one? Or and if it's the top polluters, then, you know, how do you create a threshold, and it's not the top 4, maybe it's top 5 and so on?
Yeah, good question. There'd be a lot of factors that come into that. So, I mean, it makes sense if you are really seeking a meaningful monetary claim, you'd go for one or a group of them that collectively have a relatively large pro rata share of emissions, so that it's a meaningful amount, if you like. But you would look at other things like, is it state-owned, is it private? Which, if it's going to be actioned in South Africa, you'd look at the jurisdictional issues that Michelle spoke about. So which have better prospects of founding jurisdiction. And if you are proceeding in a foreign court, you'd look at what the jurisprudence is in that court as well. I mean, there seem to be some countries like the Netherlands that, for example, are quite far advanced in terms of some of the shell cases, so you wouldn't have to be re-educating the court around these issues. But yeah, it would be a really big strategic decision on who and where to institute action like that.
My sincere apologies, everyone. I certainly struggled and lost connection there. Also not able to see where we are. Karina, are you able to assist there with some questions that I might have missed or new questions?
I think we're up to date. Brandon has taken the previous hand. Now we have one hand from Richard Worthington.
Please go ahead,
Thanks.
Richard.
Thanks very much. Hi, I'm in Joburg and a volunteer with Project 90, and thanks for the great work. Just kind of thinking a bit beyond South Africa and dynamics in the region. I mean, trying to hold Eskom liable, given the state of its parlous finances, looks like a bit of a thankless task. But from a regional perspective, and given that Malawi, Zambia, and Zimbabwe have declared disasters around the recent drought that has affected their grain supplies very badly, there are companies in South Africa that kind of, do stand out as major contributors on a regional basis. So I just wonder if there's been any thought discussion about how that might work if some of our neighboring countries say, oi, liability. Thanks.
Thanks, Richard. I mean, I think all of these questions need to be on the table. We didn't particularly look at that in this report. But yeah, ultimately pressure on all emitters from all angles is hopefully the end goal. But yeah, certainly something to think about, but not something we covered here directly. Andile?
Thank you, Brandon, for the presentation. Michelle, thank you, everybody, and the CER. So, and for Sis Nomandla, for in the beginning when she was giving a testimony, first-hand testimony of the devastating impacts of climate change. So, Brandon, my question on the report is, how do we, as Sis Nomandla was talking, they've been facing this issue of floods and climate change since 2019, and it went on to 2022. And then on the polluters must pay. I don't know, I'm sure you know, but the funding that we've been getting, for instance, the 8.5 billion, right? Which I'm not really sure what's going on, how is this money spent if we're still having devastating impacts and nothing has been really, really done. And she's also alluded to the fact that there's still people missing, and nothing has happened. 2019, 2022, now we're in 2024. Then there's this thing of the loss and damage fund, which is a global fund, right? I'm not sure what's going on with that, if you have any knowledge, and how can we make sure that this money is real and we are always first in line, if that's the proper way to put it, to access such funding. Because last year, I'm not sure when they say this money is operationalized or it's not operationalized, maybe you can also give clarity on that. Because it's really sad, Brandon, that you would have all these finances being spoken about. Durban has hosted the conference, I think it's COP17 as well, when it means we've been center of these negotiations, we've been center to the finances, but where is the real money? Where is it traceable to say? Because when we speak about polluters must pay and we just speak about private companies and we point them individually, that can lead us to a point where the pollution and the climate change can be privatized, where those who have money, they can pay without knowing that, okay, they can afford to just do what they like, pollute and pay. But if we have institutions like the PCC who've received the money, we have the Global Loss and Damage Fund, that's where I think we should have access to the finances. It must be real and must be accessible back to the people, back to where we've been experiencing the damage. Yeah, so my question was, what's happening with that? how far are we? Is the money operationalized? How can we make sure that this is real, is traceable, and we have access to it? Thank you very much.
Thanks, Sandile. You raise a number of issues there. I just want to quickly say to everyone, I know we're now over time, so if you need to disappear, that's fine. And thank you very much for joining us. So yeah, I mean, the 8.5 billion, which is the JP, is very clearly not intended for loss and damage, and really is ultimately to support us with our decarbonization process. And that's within its own parameters, whether one is sort of happy with that or not. It's not being misspent because it's not being spent on loss and damage. I think what we need to be seeing is those developed nations that have promised it to really be providing the adaptation funding that they continue to fail to do year after year. So that's going to be an important one. The loss and damage fund, I mean, it's nice that it's up, and I think it's got $700 million in it, but we have needs of 300 billion per year. So that's nowhere near. So I guess an intervention like this, where we are looking at going after the wealthy emitters, is to plug those gaps where the global climate diplomacy is not actually meeting the mark. And we must also remember that money that comes out of the UNFCCC process, or should come out of it, like, for example, adaptation, comes from other states. And it's very obvious how ordinary people, ordinary communities, small businesses are really suffering the brunt of the climate impacts. But we must remember that states also pay. States are a bit funny because they're complicit in the climate crisis to the extent that they allow the polluting activities to continue, but they're also kind of the representatives of all of us and looking after the public purse. So in this equation, from a money point of view, the big emitters are winning and everybody else is losing. So again, all of those legs need to be worked at, advanced, progressed, to become more effective. And again, that's where this sort of never-ending pressure comes from. But yeah, this is the avenue where we can go after private parties that have been profiting from the crisis and make, I think the one figure is $2.8 billion of profit per day collectively. So yeah, you can see why there's a need to move the money from where it is to where it needs to be. Thanks, Andile.
Thank you, Brandon. We're going to just take last few questions there. We've got a question from Clement on screen asking, how can we hold these multinationals and polluters accountable, because they have complex and frequently changing corporate names and structures with the mix of holding companies? And then we also have a question from Nomata, who's asking, do you think South African judges have enough of an understanding on climate change issues to enable, cases such as this to basically capacitate them to rule on cases and climate change cases and class action suits such as these? Thanks, Brandon.
Thanks. And Michelle, please jump in as well. I don't want to hog the mic. Clement, yeah, that's going to be a very big piece of work for any particular matter, is to look into those structures, because I think those organizations, I mean, they literally move where their head offices are based, and yeah, have armies of lawyers trying to immunize themselves from action. But at the same time, it happens. We do have companies in court right now with loss and damage claims. So that's certainly a big chunk of the evidence that one would need to build. Great question, Namata. Yeah, I mean, even in our sort of other climate work, one of the challenges is how to, and I don't want to say this disparagingly, but sort of educate the judiciary around climate change. And yeah, I mean, there are possibly all sorts of avenues to do that, but certainly from the perspective of the court papers, is to really just formulate those narratives as best you can, to be creative, to be able to convey the extent of the crisis, the where the culpability is, what can be done easily, what can't be done. I mean, this is something that I think many of the lawyers on the call are probably grappling with all the time, and it certainly is a challenge. So that's why the idea of maybe proceeding in a country where, like the Netherlands again, the judiciary has been sitting with some of these questions for some years now, and there may be other places where they haven't.
Thank you. Christina is also asking, holding them accountable when they have three different countries in the same, three different companies in the same area.
Yeah, thanks. Similar to the response to Clement's question, I think it's about getting sort of top-notch intelligence about how they're structured, where they are, what the flows are, and then how the law can be applied to challenging them. So that's the sort of deep dive research that is part of the next steps of an exercise like this.
Thank you. Thanks, Brandon. Richard, is that an old or a new hand from you?
It's a new hand, but sorry, my mic was on and I didn't realize it.
Go ahead.
Brandon referred to the opinion, and I'm sorry if I missed something earlier, but so the report, great stuff, but I'm just wondering exactly what the opinion, if you could just point to the highlight of the opinion. It seems to be saying that yes, there's a case to be made here. This is litigatable. But if you could maybe just reiterate the kind of key outcome of the legal opinion as such. Thanks.
Thanks, Richard. Yeah, I mean, that's basically what Michelle summarized, and that opinion is publicly available. And again, we encourage you to read both that and Professor Sutherland's supporting report. The key takeaway is that there is it's viable to pursue a claim in delict for climate loss and damage against the carbon major. It obviously points all of the challenges. And remember what I said earlier, one can take the carbon major part out and apply it to a local large emitter, for example. So difficult, but possible. And there are probably other avenues of law that one could look at as well. A lot of the climate litigation at the moment is around kind of duties of care and due diligence that we don't necessarily have the equivalent of in this country. But I think, for example, Total is being taken to court on that sort of basis. Just to maybe also do the usual disclaimer, nothing said here is legal advice. And the legal opinion was a sort of, I mean, it's an in-depth but snapshot of where we are today. I think when we get to a point of instituting a claim, obviously there would be fresh legal opinions and opinions that go into a lot more depth on certain things. So yeah, I hope that answers that. Lerato, you're on mute.
I'm muted. Thank you so much, Brandon. I don't see any hands or any more questions, and we are a bit out of time. So I would just suggest and put forward and really encourage us, comrades, to share the report, read the report, and Brandon and his team are here for additional questions. Clement, is that a last burning question from you?
Yes, yes. Just I just forgot. According our climate change bill, because mostly we have to look on our policies and acts. In 4.1, a second clause says, can I quote? It said, and loss and damage where residual impact exceeds the state's ability to assist its citizen, the minister should be required to make a regulation and to address the adequately and the adverse impacts of the climate change on South Africa, and loss of damage suffered as well, and the cost of all a foreign order, to inform how the Republic may comply with any international obligation. You see, now we have also to teach also our leaders about climate change, about loss and damage, because it's a new thing. You as the judiciary, and because now people have taken the old, because now climate change is changing every day. Now we have to also make sure that they know about this climate change bill, because climate change bill already has not been implied, has not been practiced, but are still waiting for this to be implemented. It have to be implemented because the catastrophe of tomorrow, we don't have to wait like mamas from KwaZulu-Natal waiting another building. We have to take an action from right now. Thank you very much, comrades South Africans. Thank you very much.
Thank you, Com.
Thanks,
Brandon,
Clement. Yeah,
did you have comments on climate change bill?
I'll just be very quick. I mean, an ideal climate change bill would make a lot more provision for loss and damage. The one we are hopefully going to get soon does not. It's arguable whether that's the right place to. The kind of loss and damage we're talking about here is really a civil law and common law avenue. But yeah, in terms of your comment of our leaders also need to be educated on climate change, absolutely, and let's all go and do that as strongly as possible.
Comrade Christina, is that a last burning question from you? I know I might get into trouble if I don't note you there. Christina?
Yes, yeah, thank you. I just wanted to ask a question, like, we had an encounter with Human Rights Commission from Northwest Manager, and she mentioned something very sensitive to us, saying that they are not experts to all the violations we're talking about. So they went to DMRE to say, guys, we need experts to give us proof if maybe the tremor or the air pollution is really affecting there. And they got a response from the DMRE that the mine has the expert, not the DMRE. So I'm like, then this is going to affect most of communities if we don't have experts on certain issues that affect our community. How are we going to get those experts? How are we going to know where are we going to get those experts? Or does CER have or knows where to send us or as reference or something? Thank you.
Thanks, Christina. Yeah, we can maybe talk offline about your specific issues. I mean, this lack of democratization of knowledge is certainly one of the issues. That experts are expensive. They're kind of hard to find in many cases. I mean, we need them for many of the court cases we run, and then it's not easy getting the right ones. So hopefully some of the law reform that can happen is that this kind of information gets more readily available. But there are many agencies and role players around the world that are working on just this. I mean, climate change is an issue that affects everybody. So the knowledge about it should be available to everybody. And there are many who are pushing for that as well. So no easy answer there, but yeah, hopefully the trend overall will go well, and hopefully someone is available for your the matter that you're talking about as well.
Thank you. Wrapping up, Brandon, do you know anything about the Zimbabwe's Environmental Law Association looking into the potential case with Cecil? This is for Richard.
I don't know. That's the first I've heard of it, but I hope it's true.
That's good. And I'm sure we've got colleagues who may still be in this call who might also have some information. But Richard, we can just revert and discuss that separately. With that being said, thank you so much, everyone, for joining us on some parts of really cold and raining parts of the country. Your input, your engagement with us, your questions really inspire us, motivate us to keep going and to continue this work we're doing and finding those different avenues and other aspects that we haven't looked into that will continue to support all of our works in our respective works, as we all try to, leave a safer environment for ourselves and future generations to live in. So I'd like to thank you all. Thank you to our guests. Thank you to Comrade Noma and our comrades in eThekwini for keeping the struggle going. And we certainly hope some of these reports can be helpful and impactful to your work going forward. With that, thank you everybody, and we will share the recording and the presentations later. Thank you, Brandon and your team. And thank you also to Wendy for joining us and opening the session earlier this afternoon. Thank you, everyone, and have a good afternoon.
Thanks all.